Testing. It's way far behind. No. Dennis had said he was coming when I asked before, and I said, if he told me, then I assume that. Sometimes he has a last minute thing. Do you want me to call? No.
Hello, everybody. Good evening. Cape May City Planning Board is now in session. In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. Should any member of this board have reason to believe this meeting is being held in violation of that act, they shall so state at this time. Hearing none, we'll start with the Pledge of Allegiance. Before we do the roll call, everybody, please put your phones on vibrate or turn them off. Okay, roll call.
Yes, Mr. Becerra,
Here.
Mr. Jones, Mr. Riggs,
Here.
Mr. Crowley, Mr. Gorgone,
Here.
Mayor Marlick, Deputy Mayor McDade. Here. Mrs. Reed.
Here.
Mr. Lundholm,
Here.
Mr. Bedusis.
Here.
Mr. Crippen.
Okay, we're going to skip over those resolutions, and you'll find out later why. We're going to go to the minutes of July 22nd for approval.
Yes, sir.
Motion to approve the minutes. Thanks, Gary.
Second.
We have a motion by Mr. Bedusis, seconded by Mr. Lundholm. Mr. Gorgone,
Abstain.
Deputy Mayor McDade,
Yes.
Mrs. Reed,
Yes.
Mr. Crowley,
Yes.
Mr. Lundholm,
Yes.
Mr. Riggs,
Yes.
Mr. Bedusis,
Yes.
Mr. Becerra.
Yes.
Thank you.
Okay, we have an application 415 Washington Street LLC, application for reconsideration of the prior relief sought. I'm going to turn the microphone over to our solicitor to sort of give a rundown of what.
If I could just, I'll make a motion for the record to accept Mr. Baldini as our conflict solicitor for this meeting, for the record.
Is there a second?
Second.
All in favor?
Aye.
Okay. You're in.
Thank you, Mr. Chair. Mr. Ammenheiser, let me start with you. I have an 8-member board tonight. Mr. Gargon has viewed the tape, signed the appropriate certification. He will be permitted to participate. So you do have an 8-member board. It's your decision whether you want to proceed. Yes. You'll proceed with an 8-member board. You understand that? You understand that a tie means you lose. Just so I'm clear, a tie means you lose.
Right.
Yes.
Yep.
Okay. Just want to make sure before I lead you down a path.
If the motion is made in the positive.
Yeah, yeah. Okay, so this for the public and just to set the stage for the board, this is an application by the applicant to have a rehearing on the prior application that was heard last month. And your obligations in that regard are as follows. A board may, by its rules, provide that you will grant rehearings or reopenings of hearings in cases where the board believes it will serve the needs of essential justice, typically to allow for the consideration of new evidence, but it's not limited to that fact. The law is clear that an administrative agency has inherent power to reconsider, reopen, and rehear prior decisions in the absence of any legislative restriction to the contrary. The exercise of this board in allowing reconsideration is not confined to the exercise of the agency's inherent power to a narrow set of circumstances involving fraud or material change of facts of law. It's much broader than that. Rather, the only limitations on your authority to consider is the reasonableness, fairness, and good cause shown by the applicant for reconsideration. Good cause may be established by showing that reopening proceedings would, and this is a quote, serve the ends of essential justice and the policy of the law. So you do not have a specific rule on rehearings, but I will tell you this, that the model rules for planning boards do have a provision for allowing for rehearing. And those rules in pertinent part say, any applicant may move to the board for a rehearing of the matter, and they have to file their application with a brief statement of the grounds that they're relying upon for the rehearing. What I'm suggesting is that the board take this in 2 steps. The first step is listen to the applicant on the motion for the rehearing. Then we'll call for a vote on the rehearing. If you vote and decide to hear the reconsideration, then this next phase will be listening to the applicant relative to what the reconsideration is that he's looking for, and you'll then become a vote on that. So there'll be 2 votes. First, whether to allow the motion to reconsider. If you allow the motion to be reconsidered, there'll be a hearing with whatever witnesses the applicant chooses to bring in. He's entitled to rely upon the record that he established at the last meeting, so you don't have to sit through an entire preliminary and final site plan hearing again. You've all were here for it, or you listened to the tape for it, so you can rely upon that memory of that prior application in hearing the applicant tonight. Last thing before I turn it over to Mr. Ammenheiser is I'm going to ask the board secretary, do you have the appropriate notices on file?
Yes, I do.
You received them? Oh, okay. And they're sufficient under your review?
Yes, I checked them.
Okay, so we have the appropriate notices. One of the requirements for you to consider a rehearing is that the applicant must notice to the same degree that he had to notice for the application originally, which meant a new publication, a new notice within 200 feet, which Board Secretary has confirmed that the applicant has done. Mr. Ammenhauser, why don't you address the issue?
Let me ask one other,
Yep.
is there a public portion?
Yeah, oh, yes, sir.
Okay.
There's a full hearing, there'll be a public portion.
Okay.
Yeah. Yeah.
Can I also ask?
Yes, sir.
a question? Our consideration of the motion to reopen, is that restricted to listening to just the brief statement? Or could portions of the original application be involved in that?
I suppose portions of the original application could be involved in that. Yeah.
Okay.
I don't see why not. It's part of the record now.
Good?
Yep.
All right. Thank you, board members. John Ammenhauser of the DeWeese Law Firm, here this evening on behalf of the applicant, 413 to 415 Washington Street, LLC. Here next to me tonight, I have Amanda Adams, Daniel Effelman, the 2 members of the applicant entity, as well as Mr. John Halbrunner, the professional engineer on this project. As Mr. Baldini indicated, I have Mr. Halbrunner here because we know this is a public hearing, and if any technical questions arose either by members of the public or the board, I want him to be here for that. But I don't want you to sit through another application, so I don't intend to have him elicit the same testimony you heard last month related to the site plan and variance relief we're seeking. As the board will recall, and as mentioned earlier, we were here on this application before you on July 22nd of this year, just a month ago, seeking preliminary and final site plan approval and variance relief related to maximum permitted lot coverage and minimum required off-street parking for the proposed mixed-use building at the same address, 413 to 415 Washington Street. Tonight, we're back before you seeking an amendment to your prior determination of denial of that application. As you recall, there was a vote of 3 in favor and 6 against the proposed application last time around in July. No resolution has been adopted by this body yet, which I know Mr. Becerra indicated you'll find out why soon, and the reason for that is as soon as that were to happen, we would have been foreclosed from being able to attempt to do what we're doing right now and have you rehear this application. So thank you for your indulgence in that to this point. Specifically tonight, there's 2 reasons that we're asking to be reconsidered related to this application. First, as part of the original site plan application, you'll recall that the applicant was seeking to, on the 2nd floor of the building, expand the approved retail space and remove a portion of what exists right now as the one residential unit and some of the storage space for the existing business that's in that property. So we did want what we testified, there was testimony provided by Mr. Halbrunner related to that expanded space, but for what I'll get into next, I think while there wasn't any explicit approval of that, there also wasn't any real reluctance, it didn't sound like on the record, to the expansion of that space, but I think it kind of got lost in the weeds when we got into the proposed third-floor residential unit. So we'd like some clarity from the board as to whether or not that aspect of the site plan application is able to be approved, that is, the expanded retail space on the second floor. Secondarily, while the applicant's proposed use of the third-floor residential unit is allowable by city code, we understand that there was some hesitation related to the potential transient nature of that third-floor unit. Albeit, whether it was permitted or not, there was some concern, and I don't think anyone will deny, Deputy Mayor McDade, you raised the concerns on the record during the application presentation. The reason that we're asking for reconsideration related to that aspect of it is we believe that the majority of the other members that voted no, while they did do so, those concerns weren't raised by them until such time as we were foreclosed from responding. We had closed our case, the board was voting on the record, and while, again, we knew Deputy Mayor McDade's position, we weren't aware of that position from 5 of the other members that voted no. And by the time we became aware of that, it was too late for us to respond and allow any sort of limitation or condition on the approval of the third-floor residence. So what we would like to do, if the board would indulge us in allowing reconsideration of this, is to further discuss a limitation as to use of that third-floor area. So it's two-pronged in what we're asking for. Again, an amendment of the approval related to the expansion of the third or the second floor retail use and a limiting nature as to the occupancy and use of the third floor proposed residential unit. That's what we're asking for this evening.
Mr. Baldini, is that what we will be asked to vote on, those two
Well,
conditions?
what I would suggest, no, not yet. What I would suggest is that you first have to decide if the reasons the applicant has testified or brought forward, because he's not testifying, he's an attorney, but he's brought forward the reasons, are sufficient to grant the rehearing. So with the motion, I would suggest we phrase it in the positive, nice, clear record. The motion would be a motion to grant reconsideration of the applicant's application.
And at that point, Mr. Baldini, we then have to present a case as to whether or not the board would agree to reconsider and I should say amend the prior decision.
Correct. They've
Yes.
agreed to reconsider, so now you're going to have to present to the board why they should amend to allow the two things you've just indicated you would like to present to the board.
Yes,
You get 2 shots at it.
agreeable.
Yeah.
I will approve that motion.
Well, I haven't made the motion.
Oh, okay.
I'm just telling you what it's going to be. I
thought
don't
you
have
just
authority-
did.
I don't have authority to make a motion, but I think first thing, I just want to see if the board members have any questions of the applicant or any comment that you want to make before you entertain a motion.
Question over here?
Yes, sir.
And if this has to wait until we do the presentation, I'm fine with that. But when you talk about limitations, can you speak to what type of limitations before we?
We are absolutely
That's
going
what
to
they'll do.
discuss
They're
that.
asking for
Okay.
permission to
Yep.
do that.
Yeah, what I don't want to do is confuse the record and get bogged down in discussing those issues, which I suspect a lot of the board members are keen to get involved in discussing. First, want to make sure that you're willing to reconsider it. And I want the record clear, if you reconsider it, it's not because of what they're saying. You'll deal with that in the reconsideration as opposed to what they'll agree to. All right, but that you're granting the reconsideration because you found sufficient reason to do so based on fairness and justice.
It doesn't obligate us to any vote, one way or the other.
On any of the conditions, that's correct. Or you might not change it at all. Right. Okay? Yep. Good question. Anybody else? Any
Yeah,
questions?
I have a question. If, could you restate the reasoning for your 2 points, why you want this open again?
Yes. I'll start with what I think is the biggest point, right? And the reason that we really want this reconsidered is related to the third floor residential unit that was proposed and continues to be proposed through this application. When we presented in July, city ordinance, honestly, as it still sits today, right? City ordinance allows a residential apartment use above a permitted commercial use. When we presented the application, we were not seeking to impose any sort of a restriction on the occupancy or type of use of that residential unit, albeit transient or non-transient. There was a I won't call it an objection, but there was a discussion specifically with Deputy Mayor McDade during the presentation as to her hesitation to approve for that use. But it wasn't until we were foreclosed from further testimony and limitations on conditions of approval that we found out from a number of other members that they were also opposed to that use, and that was a basis for their decision in the denial. Had we known that before it was turned over to a vote, I'm just going to tell you, I would have recommended that we walk out and consider that and come in to be able to tell you we'd agree to that before you started voting. We were foreclosed on doing so by the time that we learned of the objection from the majority of the board. That is why we believe now that we're able to come back in fairness and in equity to try to address that and hopefully have you amend your vote based on what we're agreeing to in terms of the use of that residential unit.
But our
Restrictions on the
minutes, our
use.
minutes seem to indicate that there was a rather fulsome discussion of that issue prior to going to the public
So I-
comment, which would be when you would have been precluded for making a presentation.
Well, we would be precluded once you started voting, right? So we have the opportunity to respond to any comments, even in deliberation. And you're right, there was most certainly a hearty discussion on it. But the discussion, to my recollection and memory, was mostly with Deputy Mayor McDade. And while I love unanimous decisions, I don't always get them. So I knew if we were losing a vote, it wasn't, you can lose one sometimes, but you can't lose 5. And when we find out about the other 5 at the time that you're voting, we can't respond to it or otherwise limit our approval.
Yeah, my memory and these minutes don't seem to support that. I think that there was quite a bit of discussion from other board members on that very issue. The second, actually, the first point you raised was the expansion of the retail space, and
Yes.
you're suggesting that it wasn't given enough of a consideration.
What I considered it or indicated was we most certainly testified to it and there was a discussion related to it during our presentation. But when it came time to make a decision on our formal application for site plan approval, that seemed to have gotten lost and not really indicated on the record by anyone making a decision that it was really related, apparently, right, to the third floor residential nature, right? And the denial seemed to be.
Let me
hey,
phrase it differently.
Yeah, go ahead.
It was one vote that encompassed both variances.
Yes.
And what the
It
applicant,
was. We didn't bifurcate.
Correct. And I think what the applicant is saying that, hey, in fairness, it looks to us like the weight was against the residential property and not the expansion of the commercial. So essentially, what I understand he's doing is asking for a separate vote on each variance,
Right.
which he would have been entitled to in the original hearing.
And again, the minutes and my recollection don't agree with you. Because, in fact, one of the reasons I spoke up about this issue was because of the impact on the parking requirements, because you're doubling the size of your retail space. And that was a significant part of my comments and comments on the other board members. So I don't think that that issue was ignored or downplayed in the discussion of the board. I don't see it that way.
Okay, well, you can vote not to rehear it then.
I would vote not to rehear it.
We need to have a motion.
Formal.
So then, any other questions before we move on from board members? All right, so let me also indicate all members of the board will vote. You have 8 members for a 9-member board. You have not adopted Robert's rules, which Robert's rules would have indicated those members that were not on the winning vote would not vote in this rehearing vote. However, since you haven't adopted Robert's rules, you're under the more loose standard, as I understand from the case law, and that if you so desire, everybody votes. And that's the sense that I've gotten from the board here tonight. So everybody will vote one way or the other on whether the motion to reconsider should be granted, okay?
Does the motion have to be in the affirmative?
I suggested it being affirmative, and if you are against it, just vote it down. Reason why I suggest that is it's abundantly clear if you make it in the affirmative what you're voting on. You vote yes, you're voting to allow the rehearing. If you vote no, you're not allowing the rehearing.
And by the same token, if you make a motion in the negative and it's a tie vote, it passes.
So that's true. That's true. But I will tell you, I always recommend to boards that they vote in the affirmative rather than the negative, because it's a much cleaner record on appeal.
Right.
That's all. No reason other
You
than that.
recommend that the resolution be in the affirmative, not
Correct.
that they necessarily would vote in the affirmative.
That's correct. Yes, sir. That's right. I take no position on how any board member should ever vote, except for hiring me, maybe. Okay, so let me try. Here's a motion to grant reconsideration of the application heard by the board for the applicant on July 22, 2025. That's the motion. You're okay with the motion, Mr.
I'm
Hammond?
fine with that motion. Thank you.
I'll make that motion.
I'll second.
Mr. Lundholm motions, Deputy Mayor McDade seconds. Mr. Gorgone?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
No.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Badousis?
Yes.
Mr. Bezare?
Yes.
Thank you.
Okay, so before I turn the floor back over to you, Mr. Ammenhauser, let me indicate that I intend to swear the witnesses in that you may have, and I intend to swear the board engineer in. Sir, please raise your right hand. Do you swear or affirm to tell the truth before the board here tonight?
I do.
Thank you. Give us your name and your position with the board.
Craig R. Hurlis. I am the board planner and engineer.
Thank you, sir. Mr. Ammenhauser, do you have any witnesses that you would like sworn?
I know that I'm more than likely going to hear from at least two. Can I have all three that are sitting to my
course,
right sworn?
sure.
Just in the event. Yeah, so
Please,
Ms. Adams
you
first.
never have to call a witness. All right, all three of you, please raise your right hand, one after another, come to the podium and state your name, spell your last name, and give us your address. Say yes when you come to the podium. Do you each swear or affirm to tell the truth before the board here tonight?
I do.
I do.
All right, give us take right down the line. Go ahead, Mr.
Sure. John Halbner, Halbruner, project engineer and architect.
Thank you, sir.
Daniel Uffelman.
Amanda Adams.
It's your floor, sir.
Good. Thank you. If I can, Mr. Baldini, I know you just referenced the bifurcated nature of the vote that we're seeking related to those two phases of the initial site plan application that we're seeking amendment on.
Yes, sir.
If I can, I'd like to start related to the third floor residential unit and start with Mr. Uffelman, just to provide his thoughts and testimony related to the intended use of that area.
Thanks, John. Okay, again, I'm Daniel Uffelman. I'm here tonight with my wife, Amanda, and actually all of our staff showed up, which is really special. And I wanted to say thanks for reconsidering our application for tonight. I have some notes, so I'm going to read from them. I know the board's main concern from the last meeting was how we plan to use the third floor residence, and I'd like to address that directly tonight. We do not plan to use it for any transient rentals or Airbnb or VRBO rentals. As you know, we operate a high-end jewelry store, and our plan is to move our high-end jewelry store to this location. Given the security nature of our business, it's very critical that we stay secure. I think many of you guys know that we were actually robbed this last year by professional criminals. So, having any transients or unknown individuals living in the same building as our jewelry store is just, it's a serious security risk. It's a big no-no. It's really not what we plan on using the third floor for. I'd also like to note that we designed the building with an elevator, and I think someone brought it up, Marilyn brought it up in the last meeting, and it stops on all three floors. If I were to design this building and wanting it to have third floor Airbnbs or transient rentals, I wouldn't have an elevator that went to all three floors. And I just wanted to point that out. Moving on, I recognize the city and the board are considering a new ordinance for the mall zone, the C1 mall zone, regarding residential use above the mall. And in the spirit of cooperation, if need be, I am willing to accept a condition of approval that requires us to comply with any new ordinance adopted in the future regarding the use of residential above the mall. I really hope by agreeing to this condition that this would address the board's concerns and bring us to an approval tonight. And that's really, I wanted to address that head on and just really articulate my thoughts there. And I really thank you again for the reconsideration, and I'm going to turn it back over to John.
So, and I just want to follow up with a couple of quick questions. So,
Yeah, absolutely.
you referenced the pending ordinance that you're aware of related to workforce and longer-term housing in the C1 district, right?
Correct.
C1 zone. Okay. You're aware that that's not yet adopted by city council, right?
Absolutely.
That said, you're willing to, is it your testimony that you're willing to adhere to the terms of that adopted ordinance regardless of the fact that it's not even yet in effect?
Absolutely.
Okay.
Can I make a suggestion?
Yes.
The way that that proposed ordinance is written is that any existing uses
Right.
is grandfathered in.
Exactly.
So the board may want to require them to choose what that use is going to be, the use of workforce housing as opposed to apartment over a commercial use, so that the grandfather clause doesn't capture you, and so the board gets what they want.
So and this is why I just asked Mr. Hoffman, regardless of the fact that this isn't yet adopted, right?
Right.
We're willing to accept the requirement. Now, when it comes to the grandfathering, I understand that, and we're not seeking to be grandfathered in. That's why we're trying to say that what you're going to adopt, presumably, I'm assuming that this is going to be adopted, we will always adhere to. What I don't want to do, and the one issue, and I think this is just a fair statement to make, but this could be adopted tomorrow and gone in 5 years. The last thing I want to do is restrict them in any way, should this ever be revoked or otherwise gone away with, to any sort of treatment that is not unilaterally or not uniform with all those in the zone. So what I'm telling you, and I think the testimony of Mr. Uffelman is, what this requires is what they're going to adhere to. Without any grandfathering, we won't be seeking to be grandfathered in regardless of the fact that this isn't yet adopted.
Right, I just want to make sure that the grandfathering doesn't
Create an issue.
facilitate you getting something that the board's not intending.
And I guess as a question of that, would you be accepting to making sure that that is a part of any potential resolution that this board would put forth? As
Absolutely.
limiting that scope?
Yes.
Okay.
Yes.
I'm not clear what you're saying. Are you saying right from the get-go, you are not renting that to anybody but workforce people? What are you saying exactly?
Yeah, we plan on using it for Queen May at first. Forever, really. We plan on using it to support Queen May and Queen May downstairs and Queen May employees.
The other thing I'll note, that you don't even own the building yet, right?
I do not.
No,
Yeah, so by the time this is adopted, I don't know when you're going to close, but they might not even own it yet, so it may be they may be required to, there might not be any other opportunity for them to do anything but.
But are you
what's said here.
talking about workforce housing that's not working in the store?
As defined by the ordinance.
Yeah.
So question that, so the property is currently for sale?
They're under contract to purchase.
You're under contract.
We close next week on the property. But yeah, so I just want to articulate to Marilyn, we need the third floor really for our business to run it. We need storage. We may need the residential use at some point for an employee or not. We plan on using it to support Queen May and Queen May's business. We want to keep it as its current use, obviously with the condition that we'll agree to tonight that we were speaking of. But because, we never know, one day my son gets older and he wants to run the store and live above it, right? But, he would be.
So, if I may, just to sort of state it in the opposite, and I don't want to put words in your mouth, but I just want to understand. So you're basically saying that you agree to the conditions of not having it as a short-term transient rental based on the conditions, based on the current ordinance in draft form?
Absolutely, 100%.
Rather than trying to, your use of storage or your use of whatever, as long as it is not being used for that purpose, I think that's what the board would want to hear and understand. So that is what your testimony is?
Yes, and thanks for making it very clear.
No, I
Thank
just
you,
think
Maureen.
sometimes doing it the other way.
Yeah.
Makes it a little bit clearer for us. So, okay,
And
thank you.
I just have another follow-up question. So you don't currently own the property, but it's currently under contract, correct?
Yes.
Correct.
So if I could just ask Mr. Baldini, do we need some sort of mechanism that the current property owner is agreeable to this, or how does that typically work? Because I'm not familiar with that.
Sure, that's a fair question. He's a contract purchaser. He submitted the copy of the contract. Under the land use law, he has standing to come before this board and be heard with regard to the application. If you grant this application and it doesn't consummate the sale, the owner, the original owner, is stuck with whatever the approvals that were granted to this gentleman. He stands in the shoes of the gentleman. Now, he might come back and ask for something entirely different, which is his right, but not only will this gentleman be bound by that resolution, so will the prior owner, and so will future owners.
And that's what we have, there's 2 certifications in this application, one of the applicant, one of the owner, both of which were signed.
Yeah.
Okay, thank you.
So can I just finish up? Without this new ordinance for workforce housing, we would be approving you for this based on no rental on that up third floor? That's
No short
No short-term rental.
short-term. Okay.
Yes.
Yeah, what we were saying is, and what I was getting at earlier, if right now, and I'm not going to try to, I'm not complicating or attempting to, right? Right now, there is a permitted apartment above a commercial use, right? With unfettered ability to use it as a residential apartment, right now as we sit here. What's proposed is obviously going to limit that ability based on the workforce housing component and longer-term rentals. What my clients indicated is that as long as this ordinance, right, or any amendment thereto remains on the books that restricts and limits the occupancy of that unit, he's going to adhere to it. If this were to one day go away and everybody in the C1 zone could just have an apartment above a permitted commercial use like they do now, then he just wants to be treated the same way that anybody else would there. But as long as this is on the books or a form of it, he's going to adhere to it. That's the condition.
Take it a step further. If this ordinance is not approved, they're agreeing to the fact that they will not do short-term rentals.
No, if this ordinance were to go away,
Yes.
so and if that were the case, then they would be treated differently than everyone else in the C1 zone, right? Because if this didn't exist, every other unit in the C1 zone that's got a third floor or second floor apartment over a ground floor commercial would be able to have unfettered residential use of that right now.
They're granting you a parking variance, or proposing to grant you a parking variance.
That's true.
Tied to the specific use of that residential unit as well as the commercial unit. So I don't know that what you just said is consistent with how the board's going to view
And,
that.
and if I could just elaborate on that, and I agree with Mr. Hurlis with that. I understand your position and kind of explaining, hey, there's this potential ordinance that the board is going to review, make recommendations to council, potentially approve. But I think it's the job of this board to limit that scope of what's going to be on that third floor. That's the whole point of hearing a reconsideration, at least in my eyes, and understanding the direction of this property.
I think I would agree with that position, because if we're approving it based on the condition of the parking variance. And the other thing, I mean, I think in the spirit of this, council and the mayor are very much supportive of this workforce ordinance. So, I hope that we can work through whatever modifications, edits, and revisions that need to occur, at this table and also at the council table. But I think in the spirit of making sure that we as a community are supporting our workforce in any form or fashion is critically important at this point in time. So I do think we would just want to make sure, Mr. Emenhauser, sort of that language would be in the resolution so that we would, feel confident, since it is a parking variance approval.
Understood. Mr. Effelman will respond.
Yeah, and I completely understand what Craig's saying, and I'm amicable to that as well. And I just wanted to make that clear. I know John jumped in and spoke, but I am amicable to that as well. And I understand what he's saying. He's saying, we want to make sure I'm treated fairly, but I get it. I'm asking for also the parking, so, I'm also amicable to that as well.
So if I could just make it clear that if the board, moves forward, that any resolution would limit the scope of that third floor to the workforce housing.
I think
Right.
the alternative is that it's not going to be short-term.
Right, I think
Language is much, I'd rather.
Let me try.
Go ahead,
I think-
thank you.
I think the concept that the deputy mayor is getting at is a condition of approval that would say no short-term transient housing
Okay.
would be,
And that's kind of where I was trying to get to
know.
and understand
Right.
the direction of where we're going.
yeah.
Yeah,
I
because
think that's the condition she's looking for. I think that's what Mr. Effelman just said he's agreeable to.
Correct.
Right.
I think, and the reason I say that is because we are in draft form, and sort of the definitions around workforce housing and sort of, the ability to have people moving back into this community is very much a balance between the two. So I think that we're still fleshing that out, but as long as this is not a short-term rental, a transient rental, then that would be, my position, and I would be comfortable with that as far as, if that was a condition of this.
When we
Maureen,
say
that-
short-term, what's the time length on a short-term? 2 months, 3 months?
No,
What are we
the
talking?
More than
definition of This
90.
ordinance is anything short of 90 days.
90
Yeah.
days.
When we say 90 days or less.
That doesn't preclude long-term rental, like owner-occupied, doesn't preclude.
That's exactly the
They get a
point.
yearly rental from
Yes.
anybody.
Yes, that's
For any other
exactly.
reason.
Currently, those are all of the features that we're looking at within this,
Yeah, 'cause I'd be nervous limiting it strictly to workforce only.
which is why I'm
Rental.
suggesting that we go with the short-term, not a short-term transient, yeah.
Transient.
And that way, we're providing as much flexibility, which is this, we'd like to see this geared towards workforce, and I'm only speaking for myself here as a board member, not necessarily as a council member, but because I think it's important that we as a community invite people back in here to live, to be part of the community in a way that we don't have right now, that we're losing. So that's, one of my driving, interest in this, so.
And a mercantile license is required for workforce, anything, in fact, I think the criteria is 125 days.
No.
Long-term rental is 125 days, excuse me, or longer from a real estate perspective.
Now, the short-term rentals require a mercantile license.
Right, so,
Yeah.
right.
Pretty much any rental requires a mercantile
Yeah.
license.
Okay.
The mercantile license doesn't differentiate how you rent it.
You don't need a mercantile license for more than 90 days.
Yeah. I rent year-round, and I don't need a mercantile license.
You don't for year-round rentals.
Don't-
Yeah.
don't
And
less
we,
than 90, sure.
no, and we've already discussed potentially having something that identifies within our software system, if it's a workforce housing or long-term rental, just so that we have it on the record, so that we don't find someone who's, and I'm not saying you, but anyone who would adhere to these conditions, anything turning back into a short-term transient rental. So those are some of the mechanics that we're still working through, and that's why it's still in draft ordinance.
Understood.
I have a question. The application is looking for variances on a property that's not owned by them. And this discussion with regard to the application, the agreements you verbally make here, and also the fate of the ordinance on workforce housing, still remain open questions. And in that context, I wanted to ask whether or not the present owner was notified of this meeting.
He signed the application.
Signed an affidavit.
He did?
Yeah, we
Wait,
have it-
No, sign the application on what we're discussing now?
Correct. I submitted a new application for this motion to reconsider.
Okay, all right.
With new signatures.
Yes.
Yeah.
Yeah.
All right, no, good, okay. I'm just make sure that happened.
Yeah, I know, I looked at it.
Yeah.
Anybody have any other comments? Then we could, I guess, move to a motion?
So if you
Remember-
go ahead, Mr. Early.
I just have a couple of comments.
Oh, you have to do the.
So I prepared an updated memo dated August 20th, 2025. I just wanted to confirm, because I went through the whole application. I couldn't find any differences between what was originally submitted in the plans, the original plans versus this version. Is that correct? There have been no changes?
The only change that I'll indicate, which was placed on the record at the first hearing, was you recall that there was, in the initial application, there was only, the relief was only sought under the C1 criteria. We made an amendment
Okay,
to
so,
say C1 and C2.
so the application itself has been, but the site
Right.
plan itself has not changed in any way?
Now, the site plan that was submitted as part of this rehearing is exactly the same plan set that was submitted for the original hearing.
So I had gone through my recommended conditions at the last meeting. I'm not going to bore you with those again. I would just add one condition, and that is the specific language that's chosen to limit this to not a short-term rental should be added to the site plan as a note.
And I would request for clarity to define what the board considers to be a short-term rental.
Well, that's going to be
90 days or less.
crafted.
That's what I asked.
That's going to be.
Fine, I just,
Yeah.
there's
So that'll be in the resolution, but that resolution language should be brought onto the site plan so that it runs with that site plan.
And I'm going to go a step further. The site plan will be revised to reflect rental of property for not less than a certain number of days. I prefer not to use the word transient lodging because that has different definitions in the building code versus zoning, and that could be open for interpretation by someone later, which is a mess. Let's pick the day, and that's the number that'll be represented on the plan.
Yeah, so that's the only additional condition that I would recommend.
Okay. And obviously, I'll have an additional condition.
Yes.
That you comply with the board engineer comments.
And we are fine with doing so, absolutely.
So, and then I just want to make a couple of things clear before we open the hearing to the public, or if board members have any more questions based on what I say. You understand the ordinance may change. The ordinance you see in front of you may not be the end result of where council ends up. So you're committing to no short-term transient housing regardless of what that ordinance looks like at the end of the day, right?
I understand.
Okay.
The only thing, Mr. Baldi, I'd ask is, after the public's done, if I can just ask any board members if there's any concerns that we might be able to try to address before going to a vote.
Absolutely.
Thank you.
Well, before we do that, did I miss your discussion of your point number 1 on the retail space impact?
So, Mr. Halberner, when you initially presented the site plan application on July 22nd, do you recall going over the proposed second floor use and the change in that use?
I do, and it's present condition. There's rough numbers, 800 square feet of storage area in support of the shoe store on the first floor. The other 800 square feet, give or take, is apartment use that, when combined with the third floor, constitutes in total a 3-bedroom apartment.
And what we're seeking to do, correct me if I'm wrong, is by changing that second floor to a retail space, you're reducing the size of the residential use and eliminating the storage on that second floor.
Correct. The second floor, as proposed, will be 100% retail, except for the minor circulation necessary to get to the third floor. The apartment that remains on the building will exist solely on the third floor and will be a 2-bedroom apartment. So there's a reduction in the number of bedrooms, there's a reduction in the parking demand associated with the retail space, and the entirety of the second floor will be business-related, except for the stairs giving us access to the third floor.
Okay. Now, I know Mr. Crowley had raised this concern last, but so I just want to make clear, I know this is on the record from your prior testimony, which carried over to tonight, but in terms of the parking, what that does, how many parking spaces does this property currently have available?
Available, 0.
And how many are going to be available if this is approved?
0 will remain available if this is approved. Now, for context, in the existing condition, we're required to have 7 parking spaces based upon the existing configuration.
Okay.
Based upon the proposed configuration, which is much more retail-heavy, less residential-heavy, there's a total of 17 parking spaces required.
Okay.
And again, 0 exists, 0 proposed.
Okay. But what we were doing and what we're asking the board, just for clarity on tonight, related to our site plan application, is the change in use, per se, of that second floor from part residential, part storage, to a commercial retail space, correct?
Correct.
And we're asking for whether or not that is approvable by this body.
Yes.
Okay.
I had a question for Craig, too. Craig, is this retail space here, is that subject to any code requirement for minimum parking per employee?
No, not in the mall.
Okay.
Anybody else
Okay.
have questions? All right, we'll open up to the public. Anybody would like to speak? If you do come up to the podium, have to be sworn in.
Sir, please raise your right hand. Do you swear or affirm to tell the truth before the board here tonight?
Yes.
Thank you. Please give us your name, spell your last name and your address, sir.
Chris Reardon, Riordan, 8 Edgewater Road.
Can you pick up the mic because I can't hear you?
You can pick it up here. All right, how's that? Cool. All right. Hi, my name is Chris Reardon. 7 years ago, I moved down here for the opportunity that Dan and Amanda gave me with Queen May. Since then, my career has flourished. I bought a home in North Cape May, started a family, and built a future. I can speak for the whole Queen May team here tonight when I say this expansion will benefit all of us. When Queen May grows and succeeds, Amanda and Dan always make sure that our team succeeds as well. Thank you. Just gonna fall. Cool.
Anybody else care to speak? Okay, then we will close the public portion.
So with that, we have nothing more to add right now, but as I indicated, if there's any concerns that any board members have that we might be able to address based on what's presently before you, if you could just please let us know, we'd be happy to try to respond to those at this time.
I think if I could just comment, I think you've heard the comments of the board, and we can't stress enough, at least from my perspective, how important council believes that workforce housing is an important element of the future of this town. So I would just take that into consideration as you move forward with the application, the development, or anything along those lines of the property.
Absolutely.
Okay, anybody else have a comment? Anybody care to make a motion?
So-
For the
Yeah, before we do that, let me just make clear. Are you agreeing to one motion, and I'll give it to you?
Yes.
The motion would be for this board to grant variances for parking requirements for both the expanded commercial use and the residential use with condition of no short-term transient housing, and to grant preliminary and final site plan approval.
Acceptable. Yes, that's acceptable.
So that would be the motion, sir.
Okay. Anybody care to make that motion?
I'll make the motion.
I'll second.
Deputy Mayor McDade motions, Mr. Gargone seconds. Mr. Gargone?
Yes.
Deputy Mayor McDade?
Yes, so I would like to say thank you for investing in the community. I think it's critically important, both from the commercial side and your willingness to work with us on the workforce housing or non-short-term transient rental on the mall. I certainly appreciate it. I appreciate the spirit of coming back here and your willingness to make that concession, given the fact that we are in, still in draft form. But I think it's important for the business community to work with the city and the residential community to try and promote and support workforce housing in this city. It's much needed, and I certainly appreciate your willingness to meet those conditions.
Thank you.
Mrs. Reed?
No.
Mr. Crowley?
Comment briefly, unfortunately, because the resolution has not been separated by the two issues, I do recognize that some changes have been made to the apartment situation on the top, which resolves a lot of the concerns I had. However, the core concern I had has not been addressed to any great degree other than what it was last time, and I just can't bring myself to just contribute to an already out-of-control, exacerbated problem for the city. And until the city does something that's forward-thinking and progressive and tries to address this problem, I can't see dumping more load onto an already overloaded wagon. So I would have to vote no.
Mr. Lundholm?
Yes.
Mr. Riggs?
I think I made my comments pretty clear on how I feel and how I believe the property should move forward, and I think you guys have heard me pretty loud and clear, so I'll be voting yes.
Mr. Paducas?
Before I cast my vote, what does the city use to enforce our codes? Who enforces our codes?
Code enforcement, which reports to the chief of police.
How often do they go around checking on rentals like?
They probably do it when there's a complaint.
But they do also do it at the beginning of the year through the fire inspection. We now have the Rentalscape program, so they've been looking at that, and that basically gives us an opportunity to have eyes on anything that's being rented through the Airbnb and Vrbo market to confirm if they've had a mercantile license, a fire inspection, things of that nature. So they do get involved, but yeah, Bill's right. It's also during times of complaint, so.
My hindrance here is, and I'm really stuck, guys, because we were appointed, we weren't elected, but we were appointed to represent the citizens of this town. And on December 10th, 2024, you came before us for property, what is it, 518 Washington Street LLC, Block 1051, Lot 5, C1, C2, that you were going to use these apartments, it's right here in the minutes, for housing employees and their Airbnbs. You swore under oath that you were going to use these for housing employees.
Gary, I appreciate you bringing that up, and I feel bad that you feel misled, and I do apologize for that. I know that meeting, there was a lot of talk of workforce housing, and a lot was said. You know, Amanda and I, we did have an idea of using maybe one of the apartments for our manager, which we did speak of at the meeting. Since then, some circumstances have changed. She got a dog. And the other thing is we actually help her with her lease now, and we're co-signers on it, and she couldn't break it anyway. But that's just a whole other story. But again, I apologize if you feel that we misled you. And 100%, we are agreeing to this condition tonight for this new property, and we're going to stand by our word with that.
I'm going to depend on the city of Cape May to enforce its code enforcement on these properties, and I'll be watching. So for that reason, I'm going to vote yes on this, just because I want to advance the business community of Cape May, and that's what we should be here for, to create a good environment for business. So I'm going to vote yes on this, but I'm going to be watching.
I'll join you.
Mr. Bezier?
Yes.
Yeah, I'll do a resolution for next month. We will not vote, or I recommend the board not vote on the resolution that is presently before the board, since the motion to reconsider has been granted, the reconsideration has been granted, and you now have a different relief than you had under that resolution that we will not vote on tonight. I will submit a resolution within the time frame for adoption at your next regularly scheduled meeting.
Mr. Baldini, I just want to make sure that the site plan is revised to reflect the condition.
That will be a condition of
Okay,
approval.
and that also it stipulates the days versus just the language of short-term. Okay? All right.
Yep.
Great. Thank you.
See you, John.
Thanks, guys.
Well, let's
So-
deal with workforce housing.
And
Yes, please,
Mr.
let's.
Halberner.
Yes.
Just so we're clear, a condition will be that you submit the site plan to the board engineer for his review prior to of signatures, right?
There are several other
Yeah.
conditions associated with
Yeah.
cleaning up.
Yeah.
And it will now be expanded to include regarding the transit, not less than 90 days.
Okay, perfect. Yeah, great, thank you. I just want to make sure we're all clear before you leave the room. Okay, thank you, sir.
Let's talk about work.
All right, so we are, I think we're just going to, the ordinance that's on here, we're just going to,
What's that?
the one, the resolution that we passed down from the last meeting.
So I wouldn't touch any of the resolutions yet. Let's have the discussions first.
Okay.
Because the discussions relate to the two resolutions that are still haven't been addressed.
So let's start off with the one about the Cape May City Annex review.
Okay, so an annex review, hold on for a second. Have everything prepared, but in different order here. Okay, so the annex review is a update to our 2025 hazard mitigation plan. These hazard mitigation plans are done through the county. They're done approximately every 10 years, just like a normal master plan is done. This is an update to our every municipality within Cape May County gets a chapter. We're Chapter 4, and this is an update to it. There was a hazard mitigation planning team that included various representatives of your city, and they're listed on the page 1. Justin was a member of that, so if you have specific questions, he was involved in all of this. But the OAM coordinator, city manager, public works supervisor, mayor, construction official, municipal clerk were all on that, all participated in this. And these things are, these hazard mitigation plans are already incorporated into our master plan, our last master plan reexamination. This just updates it. So it is totally consistent with our existing master plan. So I don't see any reason why we couldn't recommend this, that is consistent, and that we can endorse this and forward this to City Council for adoption.
Any questions from Craig? Anybody care to make a motion?
I'll make the motion.
On the consistency review, correct, Craig?
Yes. It's a consistency review and recommendation.
Okay.
That's fine.
I'll make the motion.
Second?
So is this the motion for the mitigation plan?
Yes.
Okay, thank you. Deputy Mayor McDade motions, Mr. Riggs seconds. Mr. Gorgone?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Badusas?
Yes.
Mr. Bezier?
Yes.
Thank you.
Now, you may want to just jump to the resolution and just take them
Okay.
consistent. So the resolution that recommends that back to City Council is 8/26/2025, semicolon 2. That was part of your package.
Motion to approve the resolution?
I'll make that motion.
I'll second. Whoever.
Mr. Riggs motions, Mr. Badusas
Stereo
seconds.
here.
Mr. Gorgone?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Badusas?
Yes.
Mr. Bezier?
Yes.
Thank you.
Okay, then the next item to discuss is the pool regulations and the amended ordinance,
Okay?
which we did go through last time.
So the ordinance number 574/2025 was an ordinance amending the city code to confirm the intent and purpose of pool setback requirements. If you recall, we had some discussion with regards to that. Mr. King and I deal with many more pool applications at the zoning board level, and justifications for those variances are often not quantified in our code, so therefore the board members have difficulty in establishing the basis for granting of variances. This ordinance is meant to clarify that, and language has been added indicating what the purposes of those setbacks are, and those are included in there. I did a master plan consistency review dated August 22nd, 2025, and there are specific recommendations in our last master plan reexamination that are completely consistent with this in my professional planning experience and opinion. So therefore, I believe we can make that recommendation back to City Council. When we deem something consistent with the master plan reexamination, we also are allowed to forward recommended comments. So if you have comments, want to tweak language or whatever, you're allowed to make recommendations back to them if you feel inclined to do so.
I would just suggest that if we do move forward with recommending this back to City Council, can a copy of that also be distributed to the zoning board as well for their information? Thank you.
We're not limiting pools in any section of town as long as you meet the criteria.
Right, correct.
No, pools are not permitted in the R4.
But this is not.
I understand, but I just
Yeah.
wanted to clarify the comment because you said anywhere in town.
This does not create any further restrictions, requirements, et cetera. It just clarifies, hey, we have these requirements, We have a 10-foot setback requirement. We have a landscape buffer requirement. We have a distance separated from a principal structure. This gives you why we did those things, and the purposes are set forth in there.
Safety.
So you could meet those requirements and still not be able to have one in R4?
No,
R4, yeah, R4 has never been permitted.
Right.
Swimming pools are not a permitted use in R4, ever.
They're the blocks that have the quads, correct?
No, they're all of those swings.
No,
Everything from Ohio to Massachusetts is R4.
Twins, quads.
Twins, quads, singles.
yeah.
Okay.
So this is not creating any further bulk or zoning requirements, just clarification.
Craig, what effect will it have, if any, on the number and frequency of variances?
The zoning board does that every year. They compile.
Yeah,
The
numbers.
It's my opinion that the intent of this is to quantify and specifically state why we have those requirements. So if an applicant comes in for a variance with regards to a pool and they're not meeting one of those requirements, I would argue that the board has basis for denying it.
Okay.
And it's stated in the ordinance.
Okay, you're clarifying the rules of the game.
You got it.
Motion to approve this?
I'll make the motion to approve it with a copy sent to the zoning board.
I'll second.
Mr. Riggs motions, Deputy Mayor McDade seconds. Mr. Gorgon?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes,
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Badusas?
Yes.
Mr. Becerra?
Yes.
Thank you.
And you can take care of the
resolution.
resolution
The
alongside that.
resolution needs to be approved as well. Motion to approve that resolution?
I'll make that recommendation.
I'll second.
Okay. We have a motion by Mrs. Reed, seconded by Deputy Mayor McDade. Mr. Gorgon?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
yes,
Mr. Lundholm?
Yes.
Mr. Riggs?
Will a copy of the resolution be sent to the zoning board along with the recommendations, so it's all together?
So you want the, Mr. Hurlis's memorandum with it? Yes.
Yes, please.
Yes.
I'll be voting yes.
Thank you. Mr. Badusas?
Yes.
Mr. Becerra?
Yes.
Thank you.
For the record, Mayor Moloch just joined the meeting. He was saving our-
I apologize, yeah, I apologize. I had an important meeting I couldn't miss, but I apologize, Mr. Chairman.
No problem. Okay, so before we discuss the workforce housing ordinance, you want to say something about the R4?
Sure. So, if you recall, in our master plan recommendations, we recommend that a comprehensive study be done of the R4 district. During our master plan reexamination, we found numerous issues that need to be addressed. So this is the basis. I started the study. I inventoried all of the block and lots with their uses. I incorporated the language. So the first, and I'll take you through my memorandum dated August 19th, 2025. On page 2 is the first recommendation that deals with, and it specifically says that we should comprehensively re-examine and address the standards in the R4 district. Additions and accessory structures and fences in this area have been problematic from an emergency access and light, air, and open space standpoint, and can disrupt the original campus design and open space pedestrian access ways abutting the quads and two-family structures. Not permitting fences or permitting fences, but require an appropriate setback to facilitate public and emergency access while preserving light, air, and open space should be considered. Standards for corner lot situations need to be developed and addressed. Due to the uniqueness and complexity of development of this area, further detailed study is required. Property survey evaluation may be required. And so I included, so someone was asking about the R4. You can see the extent of the R4 district. It encompasses parts of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 18 blocks, I believe. So On page 3 of 13, there's an aerial view that shows kind of the density. On the second photo is an illustration of a potential problem that was brought to light, is the proximity of fences being established in close proximity to common access ways. So, and I'll explain how the layout of those blocks works at the end of this. On page 4 of 13, there's another example of how close someone put a fence to a public access way. Number 14 is the next recommendation, was comprehensively re-examine and address the standards for R4 district. HVAC structures and condensers should not be permitted in the front of the building facade. We have actually already started to address that because we had someone start to put AC units on top of the structures. So there's an ordinance that was crafted to address that. We may want to take that a little bit further. 15, comprehensively re-examine and address the standards for R4 district. A per-unit requirement is necessary for 4-unit quads. So the way that our ordinance is written is that they treat these as one single lot, even though they're individual, they have, the lot line falls on the common party wall. So there's 4 lots for each quad. Our ordinance doesn't address it. It treats it as one big lot. So I recommended that we need to break down the standards that we have in the code to address lot sizes for 1/4 of what they're permitted to be. We kind of have been doing that on an administrative level, but it really needs to happen, and that everything should be changed. So I don't see that as being a huge endeavor. 16 is the next recommendation, to comprehensively re-examine and address the standards for the R4 district with regards to quads located on corner lots. Rear yard setback should be measured from the property line opposite the main entrance to the dwelling unit. Main entrance is not defined and should be, or better methodology be developed and incorporated for establishment of setbacks. So there's issues with regards to measuring setbacks on corner lots for quads. Okay, 17, this was more of a recommendation and is more of a policy decision, I believe, but it says, due to the relatively high real estate costs within the city, many full-time residents call this area home due to the lower average cost dwelling units that this area contains. These units are often small and do not contain the bedrooms necessary for families. Cape May should ensure that this area is affordable to residents and possibly facilitate carefully planned zoning regulations that may allow additional bedrooms that support these families. Care should be taken so that redevelopment is not encouraged, so that its family homes would not be replaced with second homes. So we want to allow potential, I think the nexus of this recommendation is we want to allow possible bedroom expansions, but we don't want to turn this into a redevelopment area where houses are being torn down and redeveloped and driving the cost of living up for these units.
So I think unfortunately, even in 6 short years, this is extremely dated, because the R4 has turned into an area that is completely changed in the last 6 years. In the last year alone, 30 homes were sold. They're becoming more, not even,
That's not a lot.
no, well, it's a lot when you're talking that it's.
Historically.
Right, I understand. But I'm just saying, the fabric of that community is changing. I live there, I know it. And so people who are still there are surrounded by, it's becoming more commercialized. It's not even second homeowners anymore. These are developers coming in and purchasing these. So I think whatever we can do to look at this, but again, try and keep with the integrity of what this area was meant to be and should be.
Right. There was a group of recommendations made for the R4 district, and that was the summary of all of those. So it's a very sensitive area, and any decisions that we make with regards to zoning changes there can have significant impacts to that neighborhood. It's a quaint neighborhood. It's, one of the lesser intensely developed zoning districts within town. So we just have to bear in mind that whatever we propose there should be done with the utmost thought to how it's going to affect the community. Okay?
Okay.
All right, so that's a summary of the recommendations. On page 5 of 13, I highlight the current zoning requirements, just so everyone has those, and I'm not going to go through those on an individual basis, but page 5, 6, 7, and 8 all indicate those zoning requirements. There are 3 primary uses within that district: the quads, single-family detached, and semi-detached. So there are separate standards for each type of dwelling unit. And you'll note, this is one of the more controlled zoning districts. At the bottom of page 8, you'll see table 3. You'll notice that there's building height is limited to 20 feet. That's the lowest in town. Every other district, the building height is 35 feet. The lot coverage requirements are pretty much 45% or 50%. In addition to our standard floor area ratio, and by the way, this floor area ratio supersedes the stuff that we have in town. These are far more restrictive. If you notice, those floor area ratios are 28% or 36%. That is far less than what's permitted anywhere else in town. We also have a lot usage ratio. We don't have one of those anywhere else in town. That ratio is, in addition to your floor area, it controls the amount of accessory spaces that you have, where a floor area ratio does not. So there are significant controls in this district that are not that are not implemented in any other district, is my point. On page 9 of 13, I go through a block-by-block inventory. So it tells you what block it is, what street it fronts on, what streets they front on with the side streets, and then the primary uses. So for instance, on block 1159, it fronts on Wisconsin Avenue. The side streets are Pittsburgh. So it's Wisconsin Avenue between Pittsburgh and Trenton. The uses in that block are semi-detached. So they're twins, side by sides. And then I make notes of it's a half block, so in this case, it's not encompassing the whole block. And I talk about the driveway, garage parking, on-street parking, whether there's, and I'll just show you a different one. Block 1140, or block 1158 below that is entirely quads. I just describe the parking, banks of 4 on-site parking spaces along streets with on-street parking in front of homes. Sidewalks extend along the entire block length. Sidewalk connections between quads from parking banks to the center block green space. That's what's typically exists in those blocks. So there's descriptions. You'll notice 1, 2, 3, 4, there's 5 blocks that contain entirely quads. The majority are semi-detached or mixed semi-detached and single families. On page 11 of 13, it's an illustration of our typical block layout, showing typical lot sizes, lot frontages, and orientation. If you look at a block 1157 at the top of that illustration, and these are excerpts from the tax map, by the way. 1157 is all semi-detached. Block 1156 is a mix with single-family dwellings and semi-detached. If you turn to the next page, at the top of page 12, the illustration shows block 1155. They are all semi-detached. And then block 1154 is an illustration of what our typical block looks like that contains all of quads. And you can see on that tax map how each one has an individual lot, and how the quad sits in the center of those 4 lots. It also shows a little hatched area where the 4 on-site parking spaces exist. And it's weird because you have parking spaces for the rear unit that are contained on another lot, the front lot. Weird circumstance. And I know Mr. Becerra has stories about the history and legal issues that has created. You also notice mid-block along the entire back or in between the quads that front on each street, there is a green space with access easements and utility easements that are there. You'll also see running between the quads, going from street to street, from the bank of 4 parking spaces, there is a sidewalk easement that goes in between the structures, that goes back to the green space. So it's very complex. Like I said, anything we do here has to accommodate the existing campus layout that exists in these blocks.
Craig, who owns that green?
Yeah, that, I was just going to ask, because that's become somewhat,
I can't tell you, the tax map says there's a declaration of covenants that covers that. Until that stuff was investigated, I can't really tell you who owns it.
so I think that it needs to be part of this review, because there's areas where there's been infringement, and it's sort of created more issues, especially in those areas where, on the quad blocks, especially in the older area,
That's the only
Illinois,
area that
Ohio.
has it, is the quad blocks.
No, what I'm saying is, it's not as predominant, Bill, in the, when you get to like Wisconsin and Missouri. It's much more contained and confined and much more sort of infringement, but when you're in Ohio and.
The newer they are, the more.
Yeah, they have more space back there than they do in the other ones. So I do think it needs to be defined in some way. It does create some issues, especially on the zoning side, as to what gets put back there and what's permitted, so.
Who's responsible for it?
Right.
Well, so I was hoping to get, in going through this exercise and looking at, at this study, I was hoping to get a consensus from the board into which direction they wanted to push me to start crafting zoning changes and recommendations with regards to this. So what should I focus on next is my question to the board.
Well, one I could tell you primarily is define the quads and getting the lot size
Okay.
set up.
I would say the green space would be very beneficial. I think the other one that you note here, which has been problematic, is emergency access because of that infringement into that green space issue. There's things back there, and in fact, Deputy Manager Riggs and I spent probably at least 2 or 3 afternoons walking through some of those spaces to take a look at it, and it's just sort of undefined at this point. So there's sheds in the middle of those areas, there's fire pits, there's gazebos, there's patio setups, where other neighbors are not clear what's permitted and what isn't for them. So,
Would that include the fencing?
and the fencing should be included in these areas to take a look at. It's been so undefined for so long, especially in the quads, and I would say in particular, the inner courtyards. That's where some of this is just sort of developed organically.
The fencing is all Village Green or just the quads?
Well, there's fencing permitted in Village Green now, in the back, but in the quads, there's always been this question as to
The
what
structure
would be.
It's my opinion that the structures in the quads have created the most issues. The accessory structures on the side-by-sides, the semi-detached, don't seem to be problematic.
No.
There seems to be a methodology to that development pattern that is appealing to the eye and creates a nice streetscape. So in my opinion, I didn't see anything that was super problematic there. So I think I should focus on the quad stuff, cleaning that up. I'll start with that, and then we'll talk after that. Okay?
I agree with that. Like the deputy mayor said, we spent a few afternoons walking these areas, and I just was like, oh, well, that's quite interesting. So I certainly think it's somewhere where we should start to focus and study.
Okay.
I have a question to ask, like, for instance, on the twins and things like, you mentioned, that it'd be nice to be able to, like, add a bedroom to some of the smaller units and things like that. And I know a lot of people have converted their garages, for instance, into a bedroom or another room, or attic space into a loft or things like that. What about twins? Someone buying both sides of a twin and breaking down the wall in between and making it one unit?
I did a windshield survey, and I think there's a couple animals out there that exist.
Yeah.
I think it's already happened.
But is that an allowable thing?
Yeah, it's no different than you buying 2 lots in town and building a bigger house.
Okay, that's what I was wondering.
So it's permitted, we can't stop it.
I had a comment, Craig, actually based on what Maureen was saying. This section of our code is, what, 30, 40 years old?
It's more than 30.
It's
Yeah.
50.
So,
Yeah, I think these things are 50 years old.
yeah, that's true. So, do we want to get into a discussion about what we think R4 should be in 2029, 2035? Or should we just decide to go back in and tinker with the elements of the 50 or 60-year-old code? And your point is, I think, Maureen, that the Village Green is pretty much like every other place in town. It's going through a significant amount of transition into all kinds of markets that nobody envisioned 60 years ago.
No, I don't think anyone envisioned it, probably.
Start off
When you say
as
that,
retirement
though-
housing. It was age restricted when
Yeah.
it first started.
When you say that, though, what kind of changes is it going through? I'm curious.
See, well, for one thing, there's an awful lot of rental units in there.
Village Green has always been the prime spot to get an affordable rental.
Yeah.
It's no longer the case. A quad now is going for 665,
Relatively
685.
speaking.
Relatively
I mean,
speaking.
that's where most of the people had
Okay.
year-round
Yeah,
rentals. The
right.
younger people lived in Village Green. I'm not sure about
And
this rental. what
another
we're getting at
example
there.
was just said, people are breaking walls through duplexes and making one big house out of it. Was that envisioned? Is that a good thing or a bad thing?
The use, what was envisioned when they were first built was it was for retirement people.
Yeah.
And there was an age restriction, it was 55 or older. This was back in the 60s and 70s. And they realized they weren't selling to retired people. There weren't that many people retiring here, so they took the age restriction off. And then it just became, real estate in general. First place I ever bought was a twin on Virginia Avenue. I paid $26,000 for it.
Right, and I'm not making any point at all, except the fact that it's so different from the way it used to be. Is our code caught up to that? Is it facilitating the new uses of this facility?
There are no new uses. They are residential uses.
Right, well,
All of those,
Residential uses. You keep saying commercialization. That is not the case. They're residential uses. Families live there. Whether they're seasonal or year-round, it's still a residential use.
yeah, form of ownership doesn't matter.
Doesn't matter.
So, I mean, I personally, because I live there, and I would like, yeah, no, I know. I would like to see, I think the issue of the quads and the green space, I've heard from the homeowners and the property owners wanting to have clarity around that. And I think it would be extremely helpful, because what happens is people just, wind up doing what they want, and then others are looking at it saying, wait, I got told I couldn't do that. And so you have this, it creates a lot of confusion and a lot of.
So there's no association, but there's some kind of
No, there
a,
is an association.
There is an
Maureen's
association.
the president of
I'm
it.
the president, so.
all right, so there's
It's
no.
not an HOA, though, Marilyn, yeah, no. no.
I understand that, but you don't have any rules that say you can and can't do certain things?
No, our rules are the zoning. In fact, the former website listed the R4 zoning regulations for people to know. And we try and put out information that comes to us from the zoning officer. My most recent newsletter went out with some information along those lines. I have a community event once a year, invite city administration to come, and we talk about some of these issues. If questions come to me, I refer them to Bruce or to Lou Vito, to make sure that the homeowners are talking directly to, the city, experts on it. So I try and facilitate. I get a lot of sidewalk conversations, but I always pass along the comments, or I'll tell them to reach out to the deputy manager to get some answers or information. That's how some of the most recent changes came about. The three ordinances that we proposed were from feedback from homeowners. So it's getting, now we're a bit more energized around looking at that and get a lot more feedback. People want to understand what they can and cannot do on their property. And it can be confusing at times.
What is the feedback as far as rentals go? And I'm specific.
So I think.
Short-term rentals appear to be a problem to the city, so I'm just curious as to.
I think the people who are elderly, who have lived there for a long time, They're concerned because now they have a house that gets sold next to them, and it's a rental property. So they've got people in and out who are down to enjoy their time. You know how small the spaces are down there. And so people are right on top of each other. There are still a good number of seniors, a lot of people living on their own. And so when they have that situation, it's sort of like, what do I do? I can't call the police, every time something happens. They don't want to do that. So I think for them, it's a matter of the changes that they've been there. Some of them have been there from the 70s and 80s, and now, it's changed tremendously from when they bought those homes and they came here to live. So it's hard. And it has a lot to do with the physical space, too, the limitations.
So you're implying to eliminate short-term rentals in Village Green?
No, I didn't say that at all. All I said is that people bring their concerns forth. Look, you're not going to eliminate short-term rentals in Cape May, and Village Green is no exception to that. It's just a recognition that the actual geographic space, when you look at a quad that's only 11,000 square feet, and it's 4 units, yeah, I mean, people are right on top of each other. So you can appreciate, you're living here, you're in your 80s, and you've got people coming in every other weekend and, doing their thing. It's a change for people. So, it's just an acknowledgement of the facts.
A piece of information that could inform this discussion might be, for example, how many people actually do live in the Village Green?
I have that number, Dennis. Yeah.
What is it?
Well, right now, off the top of my head, I don't have it, but I do have the data that I actually get from the tax assessors, and we do a yearly membership. But probably somewhere in the ballpark, I'm just going to guess, but I'll confirm it. Let's just say 20 to 25% at most.
Yeah, okay, I'm surprised it's that much, actually.
And it may not be, I may be overstating, to be honest with you. Of the last year, 30 homes that were bought and sold, only 3 people moved to Cape May full-time. So that's 10%. So that may be more the reality of the number.
So Craig, do you have enough direction, I guess, from the
Yeah,
board to
I'm going to
move forward?
spearhead looking at the quads. I'll start there and see if we can get some traction going with regards to making changes there. I think that's the biggest area of concern right now. And then we'll look, that'll evolve into, I'm sure, a discussion further along the line.
Okay.
So thank you.
Okay, we'll forward with that. We have one more item on the agenda, which I'm sure isn't going to take us a short period of time. That's the workforce housing.
Okay, so I prepared a consistency review, but it might be a little bit premature. I think I expected that this was going to be recommended to us from the governing body. However, I think a proper exercise at this point is to look at this draft ordinance, because that's what it is, a draft ordinance, and make recommendations. Is it acceptable, the language? So just briefly, I'll take you through what this new ordinance proposed to do was define workforce housing in our definition section 525-4. I'm on page 3 of 5 of my report, but you can be looking at the draft. So it defines workforce housing. We had a little bit of this discussion before, but as used in this section, workforce housing means apartments located above commercial uses that are dedicated exclusively for owner occupancy, workforce housing or long-term housing. In all cases, workforce housing shall, one, be rented or occupied for a term of not less than 90 consecutive days, and 2, serve as the primary place of residence for the tenants or owners. For the avoidance of doubt, no developer, applicant, owner, or operator of workforce housing shall be permitted to use such units as a short-term rental or obtain a mercantile license for such pursuant to Chapter 310, Article 4. So,
Can I go back there for a second?
yeah, we can chop this up.
Okay, all right. I mean, I didn't realize that the mercantile licenses were time-specific. I thought you had a license for rental, and it didn't say whether it was short-term or long-term, or
You don't
it's
need
just For you're right, you told me.
Yeah, yeah.
It is.
But whether you do a, I guess I'm trying to figure out where it specifies that a mercantile license is controlled by the time frame. Whether it's,
I thought it was controlled by, that short-term rentals are considered anything under 6 months, and that was the condition for the mercantile, but we would have to go back to the
No,
city.
no, it's 90 days.
90 days? Okay.
so,
Yeah, I seem to remember the city solicitor mentioning 90 days was
Yes.
chosen because that's what the differentiation
That
is
comports
in
with the
between a
state
mercantile
law
license.
defining a short-term rental, which is 90 days.
so you don't need a license if it's in excess of 90 days?
You do, because that involves my rental, and it has to be, I think, 180 day. Sorry. I could go home and look at it. Quite a few years ago, the Supreme Court had a case out by Sewell in New Jersey, and I forget the exact story. This was brought to court, and somebody who rents year-round, for instance, I have a renter in there that's been there 8 years. I do not need a mercantile license. But something, I want to say 180 or around that number, below that, you need the mercantile license. And that was by the Supreme Court in New Jersey decided.
Well, that might be, the 180 days might be where tenant landlord laws kick in.
I don't know.
You know, that's another factor.
Yeah, I'm not an expert in the mercantile license portion of this, and I rely on the city solicitor.
We shouldn't even be playing
Yeah,
with that.
yeah, but I mean, if you recall during some of our discussions with regards to workforce housing, is we had a hard time quantifying the difference between short-term rental versus long, and this definition tackles that. It may not be exactly the way we want it right now, but this is a good attempt at saying it's 90 days, we can't have short-term, flipping over, your occupation has to be not less than 90 days. So
I
quantify
understand,
it.
yeah, this is referenced in our current code, correct?
this is a brand-new definition. We have never had a definition of
And you're-
workforce housing.
You're correct in linking it to the application for a mercantile license, because that's the only way you can get into a
Right.
short-term rental. So,
Right.
yeah, that's,
So,
that makes sense.
So I think this is a great starting point, and it may be the final draft. I'm not sure. I don't see any recommendations that I need to make, but it's quite clear at what this definition is doing. It's establishing what workforce housing is.
You want comments, or you want to wait?
I'm just
right.
rolling, I'll keep going if you want.
On that first paragraph there, the problem with workforce housing, and we had a meeting at the Taxpayers Association last week, and Curtis Bashaw attended and made a very good point in terms of identifying actually 3 tiers of housing that are actually problematic for the city. One of them is the affordable housing, which is not this. The other is seasonal housing for the folks who come in on the visas and what have you, and only going to be in here for 2 or 3 months maybe. And then the third tier is housing for the workforce who lives and works all year long in this city. And I don't see that. I think this ordinance probably ought to address that delineation in a more clear way, because it ought to say that this is not affordable housing. This is, and in some way address the seasonal impact of the workforce. And then the third layer. So if you see where I'm going here, it may be a little too broad in the first
But
set of
but I think that if you took the opposite approach, Dennis, if you're seasonal or you're living here year-round, you're still part of the workforce, regardless of the duration. You're not, so to me, being a little bit less prescriptive, not over-legislating that definition, serves the purpose for both the seasonal and, individuals who are working here year-round, in my opinion. I think that if you get too tight on those definitions, then I think people become, feel that, you're over-regulating that by definition. If they don't meet the criteria, then what does that mean? That's just my view. That's why, to me, workforce
It has to be
housing.
enforced also,
Yeah,
but,
right.
you know-
If you make, are you seasonal? Are you out of here on day 91 versus somebody who's here, who could be a J1 who comes in May and doesn't leave till October? So I wouldn't want to, do they get put in the seasonal category, or do they get put in the long-term
Yeah,
category?
I'm not suggesting any categories. What I'm suggesting is, does the language address the multiplicity of the,
I think you could have a definition of it and be more inclusive in that.
Does it capture our 3-month, I mean, what's the shortest duration of our employees staying here?
have no idea.
3 months, probably,
No.
I'm guessing.
Yeah.
So I think the 90 days captures that. So I thought that was important. It made sense to me.
Well, if you're a college student, you're not here for 3 months. If you're coming to work out of school, you're getting here in June and leaving end of August.
Could be 45 days, as little as 45 days, summer,
Or like 75, like 60 to 75.
well,
But still not 90.
No, it's not 90. And so these are the conversations we need to have. And we can define things as being seasonal that may be no less than, to put some parameters around it, no less than X, but no greater than Y.
Yeah, see, I
To
guess the
get,
point-
so,
I'm trying to figure out why we're making a distinction. I mean, either.
Well, I mean, so think about this. You can turn over this property 4 times a year. Any property. 90 days, 90 days, 90 days, 90 days.
Yeah.
Well, that's,
Is there a need to do more than that?
So what happens when the business owner doesn't own the building?
That was my
The
next
building owner has to rent to has to take a hit to house his business people's employees, when he could be maximizing his investment by short-term rental.
This is oriented to, only this use is permitted in the C1 district.
Oh, I understand that.
And it grandfathers in all existing apartments over commercial uses. So,
I get it, but what if you buy a building on the mall and you rent the business separate from the apartment, and you're not, the business owner's not the building owner? He's required to rent to workforce housing.
Yeah,
Why can't he short-term rental it? The business is not related to him.
Under that ordinance, he can rent it to any workforce person. Doesn't
Yeah, but he's limited to 90-day rentals.
Yeah, but I'm just saying, it doesn't have
Right.
to be to
Well,
that business.
no, he's not limited to 90 days. It's 90 days if it's workforce, but they could have long-term rentals.
yes, absolutely.
Okay, what the exclusion is the
The short-term
short-term
transient, and
rental only.
specifically because that's not what we consider to be a conducive rental environment on the C1. Having people transient in and out, coming in, rolling their luggage down the Washington Street Mall, cleaners coming in and out with, laundry, trash, et cetera. To me, it's more, and this was, this came up during the master plan. This was ratified as part of the master plan in 2019. The language that Craig put in here was from there. So we recognized it as an issue then, and so now we're acting upon it, which, I'm glad to see. This in no way impinges upon the ability to have short-term rentals through any other area in the city. It's just saying in this environment, this just does not fit with that streetscape.
No, I think Rick's point, if I could make your point for you.
Give it a whirl.
I think Rick's point is that on Business A, there's an apartment upstairs. That's apartment A. Can that only be used by people who work in Business A or?
No.
No,
Yeah,
no.
that's the question you had, right?
No,
No.
why should that guy be limited to, if the business owner owns a building, that's one thing, but.
he's only limited to the term of his rental.
Oh, your point is, does he have to rent it to somebody from the workforce?
Yes.
No, your point is you should be allowed to do short-term rentals above properties on the mall. That is his point,
The business
yeah.
owner does not own the building, yes.
Business does not own the building.
So you're saying basically there's two
Form of ownership
tenants?
doesn't matter when we're talking about these uses. So the use is a permitted use or not a permitted use? So
Well,
I
let me go-
don't care who owns it.
Yeah, but let me go back to the point I made it probably that well, but let me try and make it again. The thing that is not in here is a definition of workforce.
We agreed.
Yeah, well, what's that?
We're not limiting workforce to someone that has to work in the city or in that building.
Why not?
It's because we want it overall encompassing. It's not a bad thing.
How are you going to police that anyway?
Exactly.
Oh,
How are you gonna
What about,
police
what
that?
about a lifeguard who works for the city? Can he have one of these apartments?
Have it if
Yeah.
the landlord.
So long as
wants to
it's,
rent to 'em.
so long as the term is 90 days right now, so
Okay,
long
now
as he
you're-
rents it for 90 days, he's permitted to stay there for the whole.
Whether they're a worker or not.
Right.
It could be someone here for the summer visiting.
Theoretically,
Not a
yes. I mean,
short-term rental then, theoretically.
someone could, do that
maybe
and rent the
workforce-
whole thing out for the whole 90 days.
Maybe the term workforce housing is a little confusing. Short,
Midterm.
Well, the intent,
The
listen.
intent is to encourage workers.
Yes.
Exactly.
The intent is
That's
to
the
encourage
intent.
workers or these units to be available for workers.
Yes.
Yeah, and so,
Work in the city
your point.
potentially, or if they are a member working in the community somewhere.
Yeah.
It could be a
We're-
teacher, it could be a nurse.
Could,
it
yeah.
could be anyone
We're
who-
trying to create zoning opportunities. We're making zoning changes that create opportunities that are more prevalent to be used by employees or someone that's going to work in this area.
or small family.
Hard to have one parking.
It could be a small
Conceivably,
family.
Yeah, it could be a small family.
None of those things,
Yeah.
I
I
believe,
think we
are.
have too many
90
conversations
days.
going on at the same time.
Becky, Zach, we got too many conversations going here.
So, and I have a question. Are you limiting this just to the Washington Street Mall? Because C1
C1
goes.
goes outside. C1 is across the street here.
Correct.
It's
Because you
over
have,
there.
you have units, you have places east of Victorian Towers that are part of, that are in the C1 district. And I don't know how they're used today, but I know a number of years ago, I know someone who owned a condo above one of the retail stores. It was a condo. And some of those areas do have adequate parking behind them for whatever exists. So would this apply to those areas too?
They're grandfathered
If
in.
it's existing, it's permitted, it's already permitted and legalized, it will be permitted to stay. It's grandfathered in.
Okay.
And I guess the question is, how does somebody prove 5 years from now that that's what was there? If they didn't rent it out, if they didn't have a mercantile license,
Well, this person who had the.
Well, if they don't have an active
they
mercantile
might already live
license.
there.
Wouldn't they have a copy of a lease or something that they could
Yeah.
always provide?
So the land use law provides a mechanism
'Cause it-
for somebody
Yeah.
to come in and approve. It goes to the zoning board for their review. After you pass this, assume you pass this ordinance, anybody can come into the zoning official within 1 year and obtain a certificate of nonconformity,
Yeah.
which will verify to any purchaser that that use is pre-existing to the ordinance, good forever. If he doesn't come in within 1 year, any time after that, he has to go to the zoning board, and he has to prove to the zoning board's satisfaction that the use did exist prior to the ordinance. That's how your land use law handles.
And we did talk about that with Mr. Gillen.
Are those owners going to be notified of that? Because I'm not sure they would know that they have a time limit.
Right, where are you guys going with it? I don't know. I just wanted to tell you.
Yeah.
I just wanted to let you know, that's the standard under the MLUL, you know?
Why doesn't this draft mention C1?
I'm getting there. We're only talking about the definition so far. So the definition is the first part of that ordinance, so, and I'll just go, let me just go through this in broad strokes. So we're proposing a workforce housing definition. On page 4 or 5 of my report, we are eliminating apartments above commercial uses as a permitted use in the C1 district and replacing it with apartments above commercial uses limited to workforce housing as defined in section 525-4, which is the definition. Okay? Section 3 on page 5 of 5 of my report has an effect on existing uses, and that details the grandfather clause. Okay? That's the broad strokes. Those are the only changes being proposed.
Could we suggest that it be used in all commercial districts?
in the master plan reexamination, this recommendation was made for the C1
Right,
and the C2.
right.
I think this is being done in the C1 as more of a test case because it's where it's most onerous, where the parking issue is, and if we have, it's not really conducive to short-term rentals.
Yeah.
You may want to make the recommendation that they allow it into the C2. It's certainly a recommendation in our reexamination, so.
To tell you the truth, it's probably a good recommendation for all commercial districts, since the concept here is living spaces above commercial operations should be available to workforce housing. That's the theory. If that's the case, there's commercial properties in all three districts. That's why we have three commercial districts. So why not?
I think the idea of limiting it to the C1, like we just said, is more or less to look at it as a case study, and then we can have something to reflect upon for data purposes.
Dennis, I can't believe you didn't pick up on this part. Workforce housing is exempt from parking requirements.
I was just going to say that.
Under this.
Under this.
Yeah, I'm getting to that.
So,
I haven't
you
even.
want to expand that into the C2 and C3 districts?
No.
I'm surprised.
No, I want to remove it from the ordinance. That's my suggestion.
Okay.
Yeah, because that's piecemealing the parking problem. It's piecemealing the parking problem.
I think it's recognizing a certain circumstance and development pattern exists in the C1 that's different from the C2 and C3.
I think also we want to encourage this. And
this-
a way to encourage this is to take that limitation away.
I agree.
And I think that the other thing is the C1, as Craig has said, this was, within the master plan. Let's beat up the language in here. Let's do the definitions. Let's send it back to council for consideration, and then we see how it develops. This is new territory for the city. Rather than trying to do a very broad brush on this and have a lot of, probably, people unhappy or unclear on what we're trying to accomplish, let's keep it focused and make a step forward, finally.
I'd like to throw another wrench into this. Can you do an overlay and just apply that to the mall? And the reason I say that is you've got Washington Commons, which is the elephant in the room, all one-story buildings. There is a lot of potential there for family housing. They've got to limit that to just workforce housing is I think overkill, especially for that block.
So what I would ask,
I don't understand your concern there, because this would promote long-term housing. I don't think you want to see short-term housing in Washington.
You're not, but then the workforce housing is confusing. What about if they wanted to do some things where you gave them a density variance where they could build more units so that the cost was down and families wanted to buy, young families wanted to buy in there and live and.
I think what Craig is saying is that this wouldn't necessarily. Preclude that. And I think based on the discussions we've had, having a definition around what workforce housing means, I think might clarify that point for people on the board and outside of this room. But if these are the comments, then I think maybe we need to get them to Craig. He can review them with Mr. Gillenschwartz.
Yeah, I mean,
And then, bring it back to the next meeting and sort of take a look at it then and say, okay, this is ready to send to council. I mean,
No, there's other possibilities too. You could do maybe a pilot program with one of these with a property and.
well, I think this is, I would argue that this seems to be a pilot
This
program
is a
to
pilot program.
incentivize
It's right.
apartment rental types that are conducive to workforce
Instead
housing.
of punishing people for doing, like, you.
They've incentivized.
Carrot,
Yeah.
exactly.
Well, now would be, if you're going to, like you said, build something on Washington Commons, now would be the place because you wouldn't have to meet the parking requirement.
Yeah, but there's other carrots out there.
yeah, right. There's other considerations for that in
So
other
The thing
ways.
is, I think workforce housing, that term sort of kind of pigeonholes it and makes it sound like it wouldn't be available to young families or
Can,
single
can,
individuals. who-
right, can we work on that definition to get more comfort around that?
Sure. but-
Okay, because workforce housing to me means both people coming here for, as we've discussed, seasonal, as well as encouraging, people coming into the community for longer term, people who are becoming part of the fabric of the
Police-
community.
Police, firemen, if they.
Police, firemen, teachers, nurses, anything you can imagine. We need to
See, this is why I said a minute ago, why not just put a definition of what we think workforce is?
That's part of what this discussion is.
Okay,
We can get
so that's-
language and do that, and incorporate it in here and circulate it back around for the next meeting discussion.
One of the discussions was about, do you make workforce housing having to work in the city of Cape May, which is an obvious question. But exactly what you just said was why that wasn't included, was we want teachers or police officers or, who maybe aren't a police officer necessarily in the city of Cape May, but if they're in Lower Township, or firefighters, et cetera, to still meet the definition, because, you could argue that a nurse living in the city of Cape May may be even more valuable than someone working at one of the stores downstairs or whatever.
And I think
Yeah,
the
but
other
Zach, we
part.
can't, we can't, have to push back a little bit. We can't be expected to solve other communities' problems when we can't even solve our own.
But Dennis, it's not solving a problem necessarily. I think what the point is, look at the diminution of the full-time population in this city. Look at the composition at this table. What do you think is going to be the composition of boards and commissions in 10 years? We have got to reseed this community with people who want to live here. So we have to give them an opportunity to live here. And regardless of whether or not they work at Cape Regional Cooper or if they work somewhere else, if they're part of the community, they're, going to the theater or becoming a volunteer or supporting, Cape May Cares or the Community Food Bank or anything else in this city, which makes it schools, why wouldn't we want to encourage regardless of where they're working?
Well, the dialogue on this issue has always been, up to now, has always been, I'm a business owner, my people can't afford to live in the town where my business is. And so the driving engine of this issue seemed to always be that. Now we're expanding it. I don't really care one way or the other. We're expanding it to a new universe of users. But if that's the case, then we ought to make that statement in a definition of what the workforce.
And I couldn't disagree with you, yeah.
Let's talk about grandfathering, shall we?
Before you get into that, I'm just wondering if, this is to kind of expand on what you were saying, Maureen. You almost define it as the rental has to be a minimum of 90 days with the intent of encouraging workforce, to rent the space. But it's also 90 days or longer, and hopefully longer. And the longer part of it, and this goes back to, the nurses, the fire, police, and so on and so forth, as perhaps a starting point to move into Cape May and maybe move on to buy a quad, to buy a twin, and so on and so forth. So I'm just wondering, expanding the definition to using the workforce housing as an example of the minimum of 90 days. But
Do we assume people are going to be able to afford to live here?
Yeah,
Because if you have an apartment above the mall that you rent for 90 days that you want lifeguards in there, and it's $15,000 for the summer, they're going to put as many people in there as they can afford it. You could be making the problem worse. And have 10 cars, and, I mean, you think somebody's going to say, we'll do it for $1,000 a month because, people need to live here. Well, who's going to do that?
I know. This is getting too deep.
Do we want to just, given the hour, want to take our comments and provide them to Craig? And we can see if he can come back with comments or revisions or, I don't.
This is not a one or two night
No.
fix.
It's not a what?
A one or a two night fix.
Okay.
This is a lot of discussion. And there's a lot of tentacles out there.
Do we
I did
wanna-
have a comment to make about grandfathering this thing. And I think it's a bad idea to grandfather it before you have a very clear understanding of who you're grandfathering. Because unless somebody can tell me,
Choose.
Huh?
You can't pick or choose. If somebody's got a use, their grandfather.
just a minute. If somebody is using this thing for example, an Airbnb, and we know that that's happening, the grandfathering language would allow that person to continue to use it as an
That
Airbnb.
does not matter. The type of rental is not what we're talking about. We're talking about the use as a rental.
It's never going to be, it's never going to be available to our workforce inventory if you grandfather.
Can't rescind their existing use through
That's
zoning.
and there's my point. You can't assume anything. You need to know.
Rescind. You can't rescind
Can't take away the,
current use.
Why not?
Because it's grandfather.
Your
Can't take away.
your
You already have
grandfather, your grandfathering.
You already have grandfathering throughout the whole city
Okay.
inherent in your ordinance.
Then before you go much,
Dennis, you parking behind your house. That's technically your front yard because you're fronting on a street. You're not supposed to park in front yards. Your grandfather, you can park your car in that space. That's what grandfathering does. You want that to be taken away from you?
no, well, the zoning officer said that was my backyard.
That's grandfather.
So,
That's grandfather.
yeah. So before you go any further, don't you think you really want to know whether or not we're going to get any units available for workforce housing out of these buildings?
You can't dictate what people ask for rent when they own the building. That's the problem.
What you need to do is incentivize them to provide it.
That's a
By
good-
even maybe offering the ability to put more units in, or reducing the mercantile
taxes.
costs, or or do a pilot.
Now, that's a good point.
So
That sort of thing, where you're incentivizing individuals who have property to do that sort of
So
thing.
what did we identify in the master plan? We identified that there's a whole bunch of apartments that are sitting above storefronts that are not being used. We also identified we have a workforce problem. We're now incentivizing the use of those apartments, not grandfathering, you got me on grandfathering, giving them a carrot that says they don't count towards parking, that's an incentive to try and address these multiple problems.
There's
I don't see it as, it's very sound planning principles.
There's another inherent incentive, too, because if they don't have to get a variance for parking, maybe they don't have to come before the planning board, which means they don't have to pay for a lawyer, an engineer, and other experts.
That's
And that's very expensive to sell it. So there is an incentive right there.
Correct.
So,
Okay, so you eliminate them having to come, and that would be the construction office that would dictate that if they're coming in for.
That's it.
For something that needs some improvements.
But just to piggyback on what Craig just said, that really is, we're looking at empty spaces above the mall that sit empty because they can't get a parking variance. And then we also have a workforce housing problem. So to me, it's just marrying those two
So let's
issues.
limit this ordinance to the mall.
Fine.
There's so much more C1 area that is going to get, just comes up, we'll do an overlay for the mall. If that's defined as the issue, let's address that part of it.
That's my biggest issue, and I think you have, again, other than, I'm trying to think about how to say this, but you have empty ones, and then you have ones that are being used that may not be legally being used. And I say that to say that if you think there's going to be a major parking change, I think some of these are already being used for managers and things like that that may not be being used legally. So the reason I say that is I just don't see it changing all that much in regards to the actual parking issue, personally.
so in part for this ordinance, is it really looking at the C1, or are we saying something along the lines of just the Washington Street Mall or the Business Improvement District, or?
Maybe if we have all of these recommendations sent to Craig, so we can come back and look at something that's comprehensive. One, what is the definition of workforce housing? Is there a request to evaluate only the mall?
But let's also remember
Okay,
that.
that's,
But
yeah, I
let's
mean-
also remember that this ordinance, would have to still go back to council, could be amended, could be changed again
Exactly.
after it's introduced. So
Right.
do we think maybe, I hate to say this, but getting a small group together to encompass all of the comments and then work with Craig? I'm just trying to figure out the best way to streamline this, so we're not coming back again
Okay.
and
so-
working through
Is there a
this.
consensus that says that it should be only to the mall?
That's what the feeling.
Straw poll. Who says
Okay.
all to the mall?
But let me,
Yeah,
Okay.
Either way.
right. Look, right.
Craig, you mentioned, I mean, even the ordinance here is a test case. So why not make the test case the mall?
Okay.
Okay.
Okay? Just limit it for the time being. Limit it to the mall. I don't think you're going to, like you said, Zach, it's not going to be that much of a difference because you're not going to see an onslaught of store owners coming in here and saying, I'm next, I'm next. You're not going to, I don't think you're going to see that. But over time, I think
But
gradually.
you are incentivizing them by telling them they don't need to provide the parking.
That's the carrot.
Right.
Absolutely.
And that's where the parking problem really is at the mall.
Right.
All right, so,
I think we also want to throw on the table Bill's point of a minute ago, and that is that the likelihood of this being a successful program, in a large part, depends on how you incentivize this to the people who own these properties.
exactly.
There has to be something.
The carrot is more powerful than the punishment.
And Rick's point is, if he's a guy who has one of these apartments and he wants to capitalize on his property and he wants to charge $1,500 a week, and he could get that on a Airbnb, then why don't we help him out to go over that threshold? Incentivizing this program is probably the only way to get it even looked at.
Well, then add to it, no Airbnb or VRBO would be allowed. I mean, you have the mechanism to determine if something becomes an Airbnb, to determine whether they have a mercantile license or not. And from what I understand, it's been,
There has to be a fire inspection on those properties, too. So, I mean, there are mechanisms to safeguard
right.
this.
In my opinion, after hearing everybody, and what Zach has said, there's already people living above the mall now. Without a permit, without an inspection, they're living up there. This is the best solution, Dennis, right now, that we have before us. And it incentivizes them, if you don't have to have a parking space. And that hinders a lot of people from coming before us. And as, Bob said, the lawyer fees, whatever, the engineering fees, and now they can use those units for their employees, or if people want to move into this area that work elsewhere, the hospital, other police departments, wherever, teachers, it's great. Have them move into the area, and let's grow this community.
Well, as Dennis said, this is like the test case. You do them all.
Yeah,
exactly.
and we can expand it from there.
Over that.
It's all riding on the affordability of it.
Well, if you allow them, they don't have to get approvals and variances and so forth. They get a building permit. There's a lot of money and time and anguish right there.
I mean, to me, it's a positive step that we're trying to address one of several issues regarding housing here, that being one and affordable housing, being another one. But I think we need to separate that from the work.
I can't see any other path we can go down but this one.
Right, can you fashion something based,
Yes. Oh, so I think you want some clarification in the definition.
Right.
And you want to limit it to the mall only.
Yes.
Right.
And I'm happy to be part of any kind of
So,
a
yeah.
group to do it.
So Mr. Gillen Schwartz crafted this, so I'll talk to him about the recommendation.
That's the area, right?
The mall is essentially.
Three blocks.
3 blocks.
3 blocks. 1, 2, 3.
Okay. All right.
Can I just go back to the grandfathering thing? Not that I don't believe everything everybody says, but what's our attorney say in terms of grandfathering something
He's the
like
one that
this?
recommended the language, Dennis. He wrote this ordinance.
I agree with whatever your attorney said.
Believe Justin's resolution.
You can't zone
You
something.
really want to go back to your long-term professionals, Chris and Rich, because they're the ones that are going to be here on an ongoing basis advising you. So you're really better off asking that question next month when Rich is back.
And that's kind of where I was trying to get at is, try to get the comments together. Let's work with our long-term, our professionals that are here day in and day out, and then try to come back to council with a full comprehensive thing, so we're not going ping-ponging this thing back and forth. But you did do an excellent job tonight, Mr.
Thank you,
Baldini.
You got a sense, Craig?
Yeah, so I'm going to make these recommendations to Mr. Gillenswartz, and him and I will work on crafting the language that you guys are looking for.
Before we close out, Jules, you have something?
You have to pass our bills too.
I'll make it short, but I prefer, oops, my knee's going bad on me.
Sitting too long.
If you pass those around.
Well, what is it, Jules?
We found out with the mercantile licenses, when we hired a consulting firm, that we have like 900 properties that should have mercantile licenses.
Now, Jules, I need to stop you there. There's been further investigation, and I don't want to speak for the city manager or the deputy clerk, but those numbers are being worked on and being revised. So I don't want that to, so I apologize, but.
Okay, well, one of the things that I think is very, very important, first of all, I agree with workforce housing. I think it should stay in the mall, but I think you need to know exactly what exists in the mall in the way of pre-existing non-conforming housing, or not just housing, uses. I believe strongly that there are a number of properties that have been illegally converted and would not pass muster if there was an investigation. It's not a lot of properties, and I think that should become a priority so that you know exactly what it is that you're going to end up modifying if you do a workforce housing ordinance that deals only with the mall itself.
Well, Jules, we're also talking about the possibility of maybe buildings adding, and not just what's there now, but adding second and third floors to provide workforce housing. There's more to it than just going after.
Well, then you're increasing the parking problem if you're going to add more.
The point is, workforce housing is more important. That's the sense that I get from everybody.
Well, the most important thing is the safety of the people that live in the city.
I agree.
And, some of us who have been in some of these buildings, and you know a lot more about them than I do, there's not fire breaks between some of these individual properties that are connected. That's got to be an issue that's known. And I think it's important to do an evaluation of each of the properties to determine where it is you're going to get your changes. That's all.
Okay, thank you. Anything else from anybody? Last motion?
No, bills,
What?
the bills.
Oh, Jesus, sorry. Payment of the bills.
I'll make a motion for payment of bills.
Second.
I already signed it.
Mr.
favor?
All in favor?
Aye.
Okay, everyone, thank you. Motion to adjourn?
Make a motion to adjourn.
All in favor?
Aye.
Thank you, everyone.
This village green stuff is not quite as easy as you think it's going to be. Village Green.
No, I know, but what's needed.
Yeah, of course it is, of course it is.
Let me tell you.
Okay.
You're welcome. The bonds, that little